Okay, so first of all, um, let me make a point or clarify a few issues. As you are aware, the NDC as a corporate body has not put any petition for the removal of anybody as we speak.
Yes.
I also want to make the point that the position of the NDC as to the conduct or other part of the Electoral Commission over the past 5 years is a matter of public record. I want to make the point that the National Democratic Congress still believes that the current composition of the Electoral Commission and how they have conducted their over the past 5 years leaves much to desire. That said, I have read the statement from the office of the president, and I've also read the letter or the communication on the the green letter for the avoidance of that.
Yeah.
In that, you see a certain communication. And Winston, if you permit me, I just want to read a portion of that, which is in quotes. While the allegations raise serious constitutional and administrative questions, they do not, on their face, meet the threshold required for a prima facie determination of stated misbehavior or incompetence, warranting that a committee be set up to inquire into this whole matter. You understand?
Yeah.
Into this whole matter.
I'm listening.
And that appears to be the position taken by His Lordship, the Chief Justice, who, under Article 146, has the power when it comes to chairpersons and commissioners of the Electoral Commission to make the prima facie determination. So, at the barest minimum, these were not determinations made by the President. The President, at this point, is just, to borrow somebody's word, a conveyor belt.
Okay.
The constitutional issues raised, and because of how our current 1992 Constitution is structured, it clearly says that when there are constitutional issues, right, you should go and invoke Article 2 of the Constitution to make a determination as to the constitutionality or otherwise.
Okay.
And so you notice that in the overall framework of the Constitution, stated misbehavior is different from a straight constitutional interpretation. And the Supreme Court has always cleverly run away from any risk couched to make an inquiry into stated misbehavior disguised as a risk. So if you recall, you remember the famous Ghana Bar Association and the Attorney General decision, popularly called the Urban case, where the Ghana Bar Association, desirous of getting Chief Justice Urban then removed, quickly put before the Supreme Court a writ of summons and the accompanying reliefs. But the Supreme Court immediately realized that the overall net effect is to try use the original jurisdiction of the Supreme Court to make an inquiry into stated misbehavior and incompetence. So the court cleverly said, no, we can see through what the Ghana Bar Association is up to. It is a constitution, it is an Article 146 matter that they have disguised and brought before us as a writ action. And consistent acted Pontius Pilate and dismiss the action. From what I am reading, it does appear that the Chief Justice has taken the position that the matters in there raise very serious administrative and constitutional issues. And so possibly the forum is not Article 146. And that those matters can be litigated in a different place other than the apex court. Now, I think we all need to exercise a bit of caution, possibly how we look at this. And why do I say so? And this has always been my personal position. I remember when the petition came for the removal of Madame Charlotte Osei, and there were no specific allegations of, say, personal use of public funds, but that there were breaches of the Procurement Act as alleged there. The view some of us canvassed at that time was that the Public Procurement Act itself envisaged instances where there will be procurement infractions. So if you note, Sections 90 to 92 of the Procurement Act provides a mechanism for addressing alleged breaches of the Procurement Act, which includes the Public Procurement Act setting up an internal audit, the audit to investigate the alleged procurement infractions, and once those determinations are made, the Public Procurement Authority has the power to set aside, that is, cancel the said procurement, or call for what is called ratification, or rectify the said mistake, among such others that are provided under the statute. So the view some of us took at that time was that if it was a case of theft, allegations made against Madame Charlotte Osei at that time, that could warrant a prima facie determination or blatant abuse of her office, that will warrant a prima facie determination. But if it was a straight case of breaches of the Procurement Act, then there are remedies provided under the Procurement Act, which should have been the first recourse. Until then, before you can trigger the impeachment proceedings. At that time, it was a convenient argument to say, and I recall vividly, when Abdul Malik Kutibakon caused a writ to be issued to the Supreme Court and raised those issues with his lawyer Samson Ladi Ayenemi. When the matter came out for hearing, I remember vividly one of the Supreme Court judges asked them, are you saying that a public authority or officer who breaches the Procurement Act cannot be stated in behavior? And that is how that fell out of the Supreme Court, in a very, with respect, cavalier manner, dismissed the Kukubako matter, where my senior Samson Ladi was the lawyer. And that's how it ended. I felt it was a proper opportunity for the court to set proper thresholds for prima facie determination. And without clear thresholds, it leaves a certain amount of quote-unquote discretion for the person making that determination to say, this one, I see a prima facie This one I do not see. And if you read the quotation referenced earlier, you will notice that words like grave, serious, repeat, you see a repetition of those words in the release.
Yeah.
What constitutes a serious misconduct? What constitutes a grave misconduct to warrant? Is it one that is whimsical? Is it one that is left for anybody to make a determination? Over the period, regrettably, there has not been proper guidelines.
Yes, but
on
Edudzi,
some of these issues.
yes, Edudzi, before you continue, because you make the point, and I look at it, and the conclusion: the allegations disclose disputes over constitutional interpretation, administrative judgment, and institutional response to complex transitional arrangements, rather than conduct so grave. That is so grave, personal, and culpable as to justify a prima facie determination for removal proceedings.
And also, they attach the question of personal.
Yes.
Personal.
So my question to you is that,
yes, please,
from a legal point of view, and if we were to add the quote here that says, while the allegations raise serious constitutional and administrative questions, from a legal point of view, don't these constitutional and administrative questions raised in the petition warrant the need to further investigate to determine the breach or otherwise?
Again, like I said earlier, current constitutional framework, for instance, says, Article 23, if an administrative body acts contrary to the rules of natural justice, the rules on administrative fairness, a person has the opportunity to go to the High Court for a determination to that effect. Would that be grounds for a removal? That's a different thing. Two, you also know that the Constitution itself says, if the conduct is unconstitutional, come to the Supreme Court for a determination to that effect. Now, these are the inherent dangers. Now, if at any time that the Supreme Court pronounces that the conduct of a public officer is unconstitutional, and if that becomes the basis for a prima facie determination, no constitutionally protected person will be safe. And I'll give you an example. From the time Dr. Afarijan was the EC chairperson, there was a case for Kenadi versus the Electoral Commission and Attorney General. Whereupon, the Electoral Commission, I think the 1996 election, on the use of voter ID card and the time for registration, Kenadi came back and said, look, he needed to be registered in order to participate in the election. The commission said the time for that has elapsed. I should think you were represented by Namado Nkwekukwado at that time. They approached the because of the view that the right to vote was so fundamental that administrative convenience and others could not be used to deny Kenadi the opportunity to be registered to vote, and therefore declared the conduct of the EC then as unconstitutional. Should that be grounds for the removal of Afarijan? Two, we are all aware of the Abu Ramadan line of cases where the Electoral Commission much earlier allowed the use of NHIS card for the purposes of proving citizenship. You recall. Eventually, the Supreme Court took the view that the use of the NHIS card for proof of citizenship under Article 42 was unconstitutional. Should that be the grounds for the removal of the Electoral Commission and its commissioners at that time? And so it's important to draw a clear distinction between a conduct that is unconstitutional on the face of it and a article. President Nana Dankwa Akufo-Addo took the decision at that time. And if you recall, of his oath of office, what are the consequences that flow from a breach? It's always important that we are building a constitutional democracy, which requires that the fine edges of the Constitution, sometimes we find a way of addressing it. I believe at the personal level that the current composition of the Electoral Commission have not lived up to expectation. As to whether that constitutes grounds for their removal is a different matter.
Okay. Thank you very, very much, Edudzi Tameklo, for joining us this morning. We're grateful.
Thank you so much for the opportunity.
Sure.